Hi, everyone, and welcome to another DOPS CBD session on Wednesday night. And let's start off with some housekeeping slides first, yeah? Okay. And let me show. Today's talk is on vaccines, medical malpractice issues, and it's very appropriate and given the current pandemic. What I'll do is run you through with you our usual discussion and Q&A platform, which is Slido. For those of you who have not uh, gone through our CPD sessions before, you can join us at slido.com and the code is 911853. And or you will scan the QR code, it'll take you to the same page. Or if you have the Slido app installed in your mobile, you can use the code 911853 to join us at the discussions. I prefer you use the Q&A, but feel free to ask questions in the YouTube live chat or in the Facebook group live chat as well. Okay. Now, you'll be able to get points live if you use the QR code, which will display at the end of the talk. Okay. Now, the QR code is valid only for about an hour or so. So if you're not watching the talk live, let's say you're watching about 2 hours later or even a few days later, I've got a system which will help you claim points without having to scan, okay? And you can claim points now using code words which will be displayed throughout the talk. So you have to pay attention and what the code words are. You see, the code word will be in a format like this. Code word equals XXXX. So you just pay attention what the word is and write it down or just note it down somewhere. So the code word will be important for you to claim points by using some special MCQs. The link to the MCQ is in the YouTube description. So, or I'll also post it in the Facebook live video in the comments. Okay, so you'll be able to click on it, log into our bulletin board, and get the point by answering the MCQs if you've been paying attention and got all the code words correct. Okay. Otherwise, I'll be displaying the CBD points in the blank space below, blank space in the center. All right. So without further ado, I'd like to introduce our speaker for tonight, and I'm very honored and privileged that she's able to speak to us again. She did so once last year, and I'd like you all to welcome Ms. Shamini Navaratnam of Siva Dharma and Association. Welcome, Shamini. How are you?
Oh, welcome, Alan, and thank you for having me back again on this platform.
Yes, it's great to have you. And I think tonight's topic is very exciting, and I think a lot of people will be very interested to hear what you have to say about vaccines. You know, I think a lot of us thinking giving vaccines is something very natural, and we've been doing it year in year out, and we're not even thinking of the medical legal issues. Okay, so without further ado, I think we will hand over the stage to you. And I'll share your slides now, Shamini.
Yes, please.
All right. So all yours, Shamini. I will.
All right. Good evening to everyone. Today, I'm going to talk about medical malpractice issues in relation to vaccines. All right. So I think the first thing that everyone is interested to know is who can be sued if any adverse outcome, one of the causes of action, or which I think everyone, especially the doctors, are very worried about, is what happens if a patient has an adverse reaction to the vaccine. So I think this is the first thing that we need to worry about vaccines. I think everybody's concerned about this. So what I'd like to do is to actually go through, firstly, who the patient or patient's family may be thinking of suing. All right. Of course, the obvious person would be, you see, I guess in the country now, there are so many different ways in which vaccines are being administered. And I think I can't keep up with the government's policy. It seems to change from day to day. Initially, I think the vaccines were, the whole responsibility was the vaccines were being given through the government hospitals and accredited teaching hospitals. Vaccines were given there. And then I think they expanded the scope. I believe now there are private companies who have been, I really don't know what is the arrangement, but the government has gone into some kind of contractual arrangement with certain companies, and they, together with the government, in the different vaccination centers throughout the country, particularly I think in the Klang Valley, these companies, private companies, are also have been contracted to administer vaccines to the general population. So these, what I'm going to tell you in this case, obviously the party who is giving the vaccine would either be someone from the government side, KKM, or it would be the private company. It would be an employee, a nurse, or whoever, doctor, employed by the private company, which has been contracted to give the vaccine. So it's very simple. Whenever you think of a claim, it must always relate back. Obviously, the patient is the main party here, but the patient will look to, firstly, they will look to the big organization wherein they went to get the vaccine. So if they went to a particular hospital, they will be looking to sue the hospital. All right. Secondly, I think, as I said, it would be the private company who's been contracted to give the vaccine. That would be the second party. The third party, I think the government recently has also allowed private clinics to administer vaccines to patients in this country. So through the My Sejahtera app or whatever system the government has implemented, the third group of people, I believe, at the moment, who are administering vaccines are general practitioners and private clinics. So obviously, I think from what I can see, I may be mistaken, you can notify me if there are more parties, but these are the obvious parties now, I believe, where the patient will be thinking of suing. Firstly, as I said, the government of Malaysia. Secondly, it would be the hospital. Thirdly, it would be the clinic. But it wouldn't just be these major organizations, because as you know, in law, we can't just sue the organization. In fact, for the government of Malaysia, Section 6 of the Government Proceedings Act says that you must actually name the officer. So naming the officer means the patient must be able, through the court process, to be able to get the name of who was the doctor or nurse or whoever it is who administered the vaccine to the patient. All right, now the patients have a lot of tools in their arsenal because there's such a thing as pre-action discovery. They can actually go to the court if they don't know who the parties are. Before they launch an action, they can engage lawyers. Lawyers will go to court and they will do what is known as discovery proceedings. Discovery means they will basically, firstly, ask for all the documents. Secondly, they can even ask for the identity of the parties who were in the clinic at that day, who administered the vaccine. They can actually go to court, and even before they launch the action, they can ask for all this information. All right, so as I said, for the government, it's very clear. Section 6 mandates the patient to actually name the party. But even so, even if it's not the government of Malaysia, if you're a victim of a tort and you want to sue for the tort of negligence, or even if there's a contract, for the tort of negligence, you must be able to identify the actual party, because obviously one part of it is the employer's liability. Employer's liability is something called vicarious liability, which means if the employee, say your organization, a private hospital, you engage a nurse and the nurse is your employee, then under the doctrine of vicarious liability, you can be sued as well. All right, that means of course, the patient only wants monetary compensation. I don't think they're looking for anything else. So they will look for the party with the deep pockets. And the party with the deep pockets is obviously the organization. All right, it's either the government of Malaysia, it's the hospital, the public hospital, or many of them now are statutory bodies, they can be sued. And the third one is, of course, it can be the companies who are giving who have been contracted to give the vaccines, they can be sued. Then, of course, it will be the doctors or nurses who actually administered the vaccine. Right, so there's a wide net. The net can be cast very, very wide just to see who can be sued when there is an adverse reaction for when a vaccine is given. All right, let me talk a little bit about private clinics. Private clinics, I think there are many models in which the private clinics are set up. Some of them, I think many of them are not sole proprietorships anymore. And I don't even think many of them are partnerships, although they could be partnerships. So if it's a sole proprietor, it's very simple. In law, you can't sue Clinic Surya. It's not a legal entity. Clinic Surya will be owned by somebody. So the patient will have to go and do some investigations, which means, they'll have to find out who is the true owner of Clinic Surya. If it's a sole proprietor, only one doctor owns the clinic, then once they do the search, they will just sue so-and-so trading as or practicing as Clinic Surya. All right, so that is in the case of sole proprietor. If it's a partnership, all the partners are jointly and severally liable. So what will happen is the patient will sue in the name of all the partners. All right, the clinic itself is usually not a legal entity. All right, and then of course the third model is it may be owned by a company. Someone may have set up a company and running the clinic, in which case the company can be sued. So this is why I will tell you that the net is cast very wide. So it will be to the legal entity, the location or the place where the organization where the patient got the vaccine, and secondly will be the actual individuals who were involved in the giving of the vaccine. All right, that's the first group of people who can be sued when there's an adverse reaction. Okay, but apart from this, apart from the clinic or hospital and the staff, the next group of people which can be sued is the manufacturer of the vaccine. Okay, and of course, it's just not the manufacturer. One of it is the manufacturer, but as you know, there is a chain of distribution. So in actual fact, everyone in that chain of distribution potentially could also be liable. But of course, the deepest pockets are the manufacturer. So if people really want to, generally speaking, I'm not talking about COVID as such. Generally speaking, if there's an adverse reaction, you would try and sue the manufacturer of the vaccine. And this has actually happened many times, particularly in the United States of America and in Europe. You will know that many important cases when there were adverse drug reactions, the manufacturer has been sued. All right, so this is the other party which big pockets, which the patient could think of suing. All right, but as you know, for COVID, it is different. What has happened is all the vaccine providers, all right, whether it's Pfizer, whether it's AstraZeneca, and I believe all the other vaccine providers, because they've had to uh, get out these vaccines in a very short period of time without having gone through the requisite clinical trials, because of public policy and public health concerns, they have actually been they've raced around the clock to get out the vaccines as fast as possible. So I believe what the manufacturers have done when they provided the vaccines to various countries is, I think they have actually made it a condition that they will provide the vaccine provided that the various governments give an indemnity in case there's any adverse reaction. They've held their hands up. They say, look, we are not going to supply you the vaccine if we are going to be potentially liable to huge claims by all the parties who are being given the vaccine in your country. And what has happened is, I think governments have had not much choice, and practically all the governments in the world, I think, have agreed to this arrangement whereby an indemnity has been given to the providers of the vaccines in the various jurisdictions. All right. All right. So here I'm just telling you in general, liability against manufacturers of medical products have been found, and then there's a case where in 2017 for the drug Tylenol caused liver damage, and Johnson and Johnson settled this claim. All right, and the basis of the claim was the failure to warn of the risk of known liver damage. But these are all just general. These are just general principles of law. This is what I spoke to you earlier about the indemnities. All right, now we'll like to know how long would a patient have to sue. All right, generally speaking, if they sue for the tort of negligence or even for breach of contract, the time limit to sue under the Limitation Act in our country is 6 years. All right, so they have a long time to come and sue. All right, and however, the period has been extended a bit by the Limitation Act 1980, where the claimant is a child or has some kind of disability, meaning if it's a brain damaged person, then the time is extended. All right. Okay, what are the causes of action? Causes of action just means how can the patient sue anyone if they go to court? That's the meaning of cause of action, all right? So cause of action could have, there could be many causes of action. Normally in medical malpractice cases, as I said, it is usually breach of contract and negligence, okay? But for vaccines, there's the additional grounds in which that they can sue. One would be product liability, and then there are certain statutes which impose criminal liability. So this is the different ways in which liability can accrue, all right? How does product liability act in this country? You see, in different parts of the world, that it's very, very strict, I believe, in the European Union and in the United States of America. So there, I think it is actually very, very difficult for manufacturers because they have a lot of statutes which protect the public and which they can be sued. And I think that the huge liability for damages to be paid to patients. But what about our country? What are the relevant legislation in relation to product liability? All right. So this is just general acts about product liability, which would also involve drugs. It would involve vaccines, technically. All right. So the The product liability, the first act that we have is the Sale of Goods Act. The Sale of Goods Act says it must be of merchantable quality, it must correspond to its description, and it must be fit for its purpose. All right, so this one is usually taken out against the manufacturer, but it also could be taken out on various people in the chain of distribution. All right, the other way in which public is protected in this country, apart from the Sale of Goods Act, is the Consumer Protection Act. All right, so, and it's similar to the sale of goods. Public is given the right, consumers are given the right to have a reasonable quality of the goods, a right to assume the goods are fit for a purpose, and when they're not, manufacturers or anyone in the chain of distribution may be held liable. All right, what about product liability? This section 32 of the Consumer Protection Act says where goods are supplied to a consumer, there shall be implied a guarantee that goods are of acceptable quality, and 32(2)(a) and B list the criteria for acceptable quality, which include fit for the purpose, acceptable in appearance and finish, durable, safe, free for minor defects. So of course, I think if you're looking at vaccines, the important one would be safe. But as I said, I think most patients will not go under this act because I think that the remedies are quite restricted. So I don't think that they will limit themselves to the remedies under the Consumer Protection Act. All right, and here again, for product liability, even though we may have all these acts again may be overridden because we do not know what arrangement the vaccine manufacturers have come to the various governments, and so it may not be applicable. The indemnity may be a blanket indemnity. All right, the more I think the method, the cause of action which most patients in medical malpractice would try and pursue. As I said, the product liability part of it may be quite difficult for them to succeed. All right, because at this point in time, there's no act or no legislation allowing them to do so. All right. As I said, the main way in which when patients are injured, they suffer adverse reactions is they will normally sue under the tort of negligence. The tort of negligence is, of course, a method in which there's a duty of care imposed on the doctors, on the nurses, and all healthcare providers and the hospitals to a patient. All right? And the three main aspects of negligence or medical malpractice is advice, diagnosis, and treatment. Of course, I think in the context of vaccine liability, the diagnosis aspect would not really be relevant. The two relevant parts would be advice and treatment. All right, advice is something I think it has become an issue, a very topical issue for all malpractice claims. And I believe it will also include vaccine claims. All right, so this is because the law in relation to failure to advise has developed in a manner where it is very much on the side of the patient and not so much on the side of the medical professional. As you would know, the law of negligence started with the great case of Bolam, which I'm sure all of you have heard of. Bolam was the case in which I think it was very, the test in Bolam was very much in favor of the medical profession because it stated that the standard of care was adjudged by your peers, so long as you complied with a reasonable standard of care, which was accepted by your peers, that would not amount to a negligent act. And that extended even to advice. It was not just limited to treatment, it was also for advice. And I think the pinnacle of that, uh, how the court would view failure to advise in the Bolam context was in the famous case of Sidaway, where Lord Diplock said that again he would judge it by the standard of peers. So when the neurosurgeon didn't, it wasn't the practice to advise in respect of damage to the spinal cord. In that case, the surgeon was successful in defending his claim, right? Because it was just an extension of the Bolam test. All right, but you see, it developed further. As you know, in Australia, there's the famous case of Rogers and Whittaker, where from a doctor-centric approach, the court sort of went 180 degrees, where it said that no, in respect of informed consent or informing of the risk, the court should look at it not from the point of view of Bolam, which means so long as you comply with the standard practice, which is reasonable and accepted by your peers, you would definitely not be found guilty of negligence. They said no, it's actually you will have to look at the particular patient. It becomes subjective, all right? So if it was important to that patient, which means it would have been material to that patient, then there would have been a duty on the doctor to notify the patient of the risk, even if the risk was remote. So that was the development of the law in the Commonwealth, which first started off in Australia in the famous case of Rogers and Whittaker. And the case of Rogers and Whittaker, the law there, initially in Malaysia, we followed the Bolam principle. All right, we followed the Bolam principle until the federal court decision of Fu Fiona. Because in Fu Fiona, it was a landmark decision because for the first time, the federal court said, in matters of warning of the risk, we would now not follow the Bolam principle, but we were going to adopt the Australian principle in Rogers and Whittaker. And basically, the Rogers and Whittaker principle is that there is a duty to notify a patient of a material risk, and the person who is going to judge that is not your peers, but it will be the judge. It will be the judge who will have to come to a conclusion whether or not it was reasonable for the doctor not to inform the patient of the risk. And for the judge to come to that conclusion, he was not bound by the opinion of experts or peers. He could look at the patient, and if it was important to the patient, the judge then becomes the arbiter of saying, this does not comply with the standard of care required for failure to warn of a risk. All right, so that's how the law changed even in Malaysia. And following on in the UK was a bit slow, but it finally came up in this case of Montgomery and Lanarkshire Health Board, where finally Lady Hale also took a more patient-centric approach to the fact of information. How much information should a patient be given? And in that case, it was about an option to have a cesarean section. So in that case, again, instead of the usual Bolam test, where you would look at the opinion of other gynecologists and whether they would have done the same for this patient, the court said no. They will look at it from all aspects, including that of the patient, and it was for the judge to decide. So in Montgomery, they followed what was the position in Australia in Rogers and Whittaker. All right, what about Malaysia? After Fu Fiona, this Montgomery principle was tested in this case called Gurisha. Gurisha, again, is a case whereby a gynecologist was sued in respect of a shoulder dystocia injury. All right, and the issue there again was whether or not the doctor should have advised the patient that she should have had a cesarean section. All right, and in this case, the High Court, this was the High Court case, the High Court in Malaysia as well took the same position as Montgomery, and they said there was a duty on the gynecologist to advise the patient for the need for a cesarean section. All right, so this case is a very, very interesting case, and it's a 2020 case. It's a very recent decision. So you will see that the courts in Malaysia as well are now in areas of explanation of risk and informed consent. They are now, I think doctors and hospitals have to be very careful in that they really require to give enough information to the patient for the patient to be able to freely consent. That's why it's called informed consent. It is not just signing a form and saying, okay, I agree to undergo this procedure. All right, it's much more than that. You must explain all material risks. All right, so let's talk about what about treatment? What is the test about treatment? All right, the treatment is actually Full Fiona is still on advice. Full Fiona was in the Zulhasnima case. Okay, advice. What about advice? So as I was saying, what about vaccines? All right, so I think even for vaccines, it's very important that there must be proper documentation. See, I don't know the SOPs in place, as I think now it's actually going to be very, very difficult because the number of patients, there are many patients being vaccinated all at the same time because we are trying our best to get herd immunity. So it's going to be difficult to give advice. All right, but I think it's still important that prior to giving of the vaccine, there must be some method or SOP in place that patients are actually, a certain history is obtained from the patient, whether they are at high risk, whether they should or should not take, whether they are more at risk for that vaccine. And if they are, you must have some kind of evidence that the patient has been notified of that risk, but they still insist that they want to they want to take the vaccine. All right, and it's not, as I said, it's not sufficient just to have the consent form. Whoever is the doctor, I don't know what's the procedure. In different organizations, in clinics, in hospitals, every organization seems to have a different procedure, or even the government of Malaysia, and how they are getting the informed consent for the patient before the vaccine is administered. And as I said, I think now it's becoming more difficult because of the volume of patients which require to be vaccinated. But please, to protect yourselves, you still have to have the form, you still have to have the patient to sign, but you must make sure that the relevant advice has been given to and the risk explained to the patients. All right. Okay, Zulhasnima and Dr. Kuku Velumani again has reaffirmed the position in Full Fiona. All right, what does Zulhasnima say? Zulhasnima, this is for treatment. Zulhasnima is not about advice. Zulhasnima is about treatment. All right. So treatment, what has happened in Malaysia, again, from being totally dependent on the view of the experts, and if the experts say it's acceptable, the court will accept it. Now it is a little bit more onerous for the practitioner to satisfy the courts that they have accorded treatment which is not negligent. And why do I say that? Because now the court says we are not just going to accept any expert who gives evidence. All right, they have modified the Bolam test by this case of Bolito. All right, and I think I'll just read this to you. A court is not obligated to find that a doctor had not been negligent simply because he could produce a body of medical opinions supporting his actions. The court has to be satisfied that the medical practice in question was reasonable and reliable and can stand up to logical analysis. What does this mean? This means that it's not that every expert you tender to court that the court can accept the evidence. If on the facts of the matter, on the medical literature, the opinion of the expert is not logical, or it was not reasonable or not reliable, then the court does not have to accept the evidence of the expert. And that is the test in Bolito. All right, what about vaccine-related negligence? All right, so I think vaccine-related negligence, one would be, as I said earlier, the failure to advise of the risks in relation to vaccines. I think this in particular has come to light not just in Malaysia but all over the world. As you know that AstraZeneca in particular had a lot of publicity all over the world when there were some cases of blood clots being reported. So I think that a lot of patients then decided that they did not want to take the AstraZeneca vaccine because of these isolated cases. But as I said, again, patients cannot be forced. It is their choice. It is actually, they have a right to choose. But as far as if they have actually turned up for the vaccine, then you're obligated to ask them their history. And if their history says that they would be more at risk, then you would have to tell them the risk. All right, so that is, if you don't tell them the risk, then you could, and that eventuality occurs, then you may be held liable. All right, so that is the aspect of the actual advice. What about the actual giving of the vaccine? Again, this is the part which I think, the administering of the vaccine. There's been a lot of, in Malaysia recently, or when it first started in May, people were recording, they were taking their handphones and they were recording how the vaccines were given. And I think there was a huge outcry when some of them said that the vaccine, they were not given the full dose of the vaccine was empty. There were a lot of issues. So I think this is the other part that I need to warn you. Right now, for malpractice matters, the patients are very savvy. They're very tech savvy. So you can expect that everything you do, whether you are explaining the risk, whether you are actually administering the vaccine, the patient is going to be recording it. All right. And if for some reason you're not doing it in the proper manner, then it's very easy for them to viralize it on social media, or worse still, to bring a claim against you. So I think obviously the best way to avoid this happening is to make sure that you have strict SOPs in place. All right, which means I believe now that the actual syringe is shown to the patient, the actual amount that is being administered is shown to the patient. The patient is asked to take a photograph of the batch number of the vaccine. And this is in certain centers. I don't know whether the practice is the same everywhere. I don't know whether this is the practice in the clinics. But again, whatever your practice is, your SOP must be in a manner that if someone queries you, you will be able to say that the vaccine was administered in a safe manner. All right. Firstly, is actually, of course, is the content of the syringe. Okay, whether the vaccine was actually placed in the syringe properly and the proper amount was administered to the patient. The second one is, of course, the method of administering. But as you said, all of you, I think the medical profession has been administering vaccine from time immemorial. So I think so long as you've been trained, I don't think there should be a problem in actually administering the vaccine. All right, unless you are very unfortunate, there is an incident. But you, in theory, could be sued for the administering of the uh, vaccine. But I think the more important part about vaccines, I believe, especially the COVID vaccines, where I believe like the Pfizer vaccine has to be stored at very, very low temperatures. All right. So again here, in order for the vaccine to have its proper efficacy, I think it's very important that there must be a system in place in the hospital, in the clinic, in wherever, in the vaccination center, wherever it's being administered, that the vaccines, are transported or kept in this. Firstly, they are sent to the center, and then they are all properly identified. And again, this comes down to documentation. I believe now the documentation, it's either physical documentation or everything is digital. I don't know. But whatever it is, every batch of vaccine which comes must be accounted for. All right. Firstly, it must be accounted for. You must know exactly what is the code for the vaccine. You must know whether you're storing it properly at the right temperature. You must be able to satisfy all the safety requirements of the vaccine. Because if for some reason you are not doing it, then again, of course, you can be sued. All right. Okay. Of course, that's one aspect. That's the physical aspect of the vaccine itself. All right. So the second part of it is, I think now, as you know, the virus is being spread because there are too many patients in close proximity. So the ideal situation is, of course, that you must be able to have a system in place that they are actually that 1.5 meters apart, and they are all masked, and all the SOPs are in place so that the patient themselves is safe. All right. So I think if all the SOPs are complied with, if the clinics and hospitals do it, then I think there's less chance of you being said to be liable. But again, this is a challenge. Sometimes when there's a crowd of patients, it's going to be quite difficult, but you must try your best to make sure all the SOPs are complied with, right? All right, there's another aspect, isn't it? Which is a practical aspect. I don't know whether you're talking about a legal aspect. And I believe the vaccines, especially wherever it is, come in certain batches. It's opened, and there are certain vials of vaccines there. What happens if the patient with the MySejahtera doesn't turn up to take the vaccine and there's surplus vaccine? Again, you must have a system in place on what's going to happen to that surplus vaccine. Are you mandated? Do you have the right to offer it to other patients of yours? Or is there a method in which the unused vaccines are supposed to be disposed of safely? So all these are questions you will have to ask, and you will have to make sure that you have a certain SOP in place so that everyone knows what it is. All right. Okay. Now this is again something which is very important, because I see now in Malaysia a lot of people are asking for information about vaccines. All right. For example, I'll just give you an example. Say if you have an office in a building, all right, one of your staff tests positive for COVID. The responsible thing to do, and what many employers will do, is they will notify the building management about their staff who have tested positive for COVID-19. All right. Now, what happens is a lot of the building management or third parties, they will request the employer to share the 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 test results with uh, with the with the building management. So can you do that? You cannot do that. All right. So this is of course not giving of the vaccine. This is more of you testing people for COVID-19. But I thought I wanted to talk about it because it's still important to maintain patients' confidentiality as well as know that this is sensitive personal data and therefore it's health related information and it cannot be disclosed to third parties. So even if you're asked about vaccine status by employers, if you're a clinic, you actually have no right without the consent of the patient to release that information to the employer. All right, it's very, very clear. As I said, we are in uncharted territories. We do not know. Government seems to say that once you're issued a digital certificate, you can do more things. But vis-a-vis a hospital or a clinic, we are still bound by the Data Protection Act. And so we cannot release this information about vaccine status to any third party without the patient's consent. All right, and of course, it also includes third parties, as in family, spouses, parents. All right, and the consent must be documented. All right, contract. What about contract liabilities? Okay, here again, because this is such a new area and a lot of it is been deemed by the government that they are not sharing this information. It's not publicly available. So I actually do not know what are the terms which between the government of Malaysia and various third parties, which is either hospitals or clinics, in respect of assisting the government to administer vaccines to the maximum number of patients. All right. So if there's a breach of that contract, in theory, of course, the government could sue, but it may also be that the third party can sue you. All right. Okay. What are the criminal law sanctions? This is basically, it is not actually under the penal code, but there are various acts in place in this country. I'm just talking about the Malaysian acts. Here we have the Poisons Act and Regulation and the Sale of Drugs Act. So those statutes have certain provisions which have to be complied with. If they are not complied with, then there are criminal sanctions. All right. But I believe that the vaccines are not going to attract this liability. All right. I think now this is the one you are more interested in. What are the defenses that you can raise in the event that a patient wants to sue you? All right. Okay. The first part, as I mentioned earlier, in respect of informed consent, which I think everyone is very well aware of now, is the physical consent form has to be signed before the vaccine is given. All right. And then if possible, as I said, if possible, I think that the doctor should also document if there was any other advice which is not in the form, which was told to the patient and family, and whether the risks were explained. All right. The second thing, as I told you earlier, is that vaccines must be properly stored, and the storage and administration of vaccines are properly documented. At the end of the day, cases are won and lost by, sad to say, documentation. Because you see, after the event, it's very easy for anyone to make an allegation against you. But if you have something in black and white, then when you go to court and say, no, the patient is not telling the truth, the true sequence of events is you give your version, and then you say, my version is supported by either my notes, by the consent form, anything. You see, you must be corroborated. Law is something that when there are conflicting versions, the court will accept the version which is corroborated. If you have a corroborated version, and corroboration is normally it's the best way is, of course, a written document. But as I said, it could also be, nowadays, everything is recorded. It could be a video, it could be a photograph. All right, so any means in which to support your story is known as corroboration. So, as I said, you need corroboration, so please document. Okay, what are the other defenses? The other defenses is the Limitation Act. All right, for various parties, including the government of Malaysia and many public hospitals, which are set up by statute, you will see that the normal period of 6 years is cut short to 3 years. All right. All right, so we don't know if, because of this pandemic, whether or not there's going to be a whether there's going to be new legislation enacted which shortens the period in which you can make a claim. All right, and this, I think, has happened in America. In America, there's actually an act where I think they have to bring their claim within 6 months. All right, no doubt America has got very high payouts for product liability. But other than that, America has been very kind to pharmaceutical companies by enacting a lot of legislation whereby patients have a very limited right to sue. And even if they sue, the amount that they get is very much less. They have a very low compensation for whatever side effects. All right, so they have actually America is the place, I think, that the pharmaceutical companies have the best chance of being protected, because there are so many acts in all the different states which limits how patients can sue for vaccine-related injuries. All right. The second thing is, of course, the patient's own condition. If the patient never told you that they were allergic or had some other health risk, then they have, obviously, you can't be held. It's less likely you will be held liable if something wrong goes on. All right. And of course, contributory negligence is if you told them you can do something or you can't do something and they proceeded to do it, that also would assist you to defend the action. And I think the best defense in vaccine-related cases would be causation, because I believe, that everything is so new at the moment. I think it's going to be very, very difficult for any patient, especially if they have comorbidities, to say it's the vaccine itself which caused them to have this reaction, caused them to have this injury or cause someone to die. All right, so I believe that it's not going to be easy for a patient to satisfy the causation. You see, in negligence, it's not so simple. First, you must have a duty of care. Secondly, you must show the duty of care was breached. The third aspect which a patient has to prove before they can succeed in court is the fact that they must prove that the breach caused the injury, caused or materially contributed to the injury or death. So here, as I said, in vaccine-related cases, given the state of research and given the state that everything is extremely new, I think it's going to be, it cuts both ways, but I think it's going to be very, very difficult for a patient to say it was the vaccine itself which caused this injury or death. All right. The final aspect of what I'm going to talk about today is in relation to compensation. So compensation, again, this is something very, very new in in our country. Government of Malaysia has at the moment not created any legislation for the limit of indemnity which the government is willing to pay if a patient brings a suit in relation to in relation to the vaccine. All right. And just as in product liability, there's no legislation for limit of compensation. The other thing is there's no legislation for vaccine-related claims and injuries. All right, so we don't have anything which has been enacted yet. But so since there's nothing, if a claim was brought by a patient, then we would follow the general personal injury awards. All right, personal injury awards. So this is what I'm saying, that this is to be compared with the position overseas. All right. So in the United Kingdom, there is a Vaccine Damage Payment Act 1979, where there is a financial contribution from a national fund to compensate those injured by vaccines. All right. So in the United Kingdom, they actually have a statute, Vaccine Damage Payment Act. In the USA, this is the one I told you where they get a small amount only. There's a thing called Countermeasures Injury Compensation Program. Victims must file a claim with a fund, and they get a very small amount. But this is one of the acts. There are many acts, but this is one of the acts for a compensation for vaccines. In Singapore, in 2021, this year, they created a Vaccine Injury Financial Assistance Program. In the Philippines, it's being discussed in Congress, but I don't think it's been passed yet. They wanted a vaccine indemnification fund to provide liability coverage. The Philippine model was actually one where they wanted the insurance companies as well to contribute to a fund, a general fund, and then and the vaccine manufacturers, the insurance companies, to contribute to this fund together with the government. And then if any victims had suffered any injuries, they could claim compensation. But I don't think it has been passed by the Philippines Congress. So this is just one of the ideas. So we do not know which way we are going to go. In fact, I think a lot of for vaccine related injuries, a lot of people say that it should not be going to court. It should be a no-fault compensation type of scheme, where they just have to say the injury and then not ascribe fault to anybody and just get compensation from a fund. But at the moment in Malaysia, we don't have any no-fault compensation scheme for any type of tortious claim. And I do not know whether they will do it. I do not think they will do it, frankly. I do not think that it's going to be implemented just for COVID-19 vaccine related injuries. Right, this I think covers the main part of my talk. But as I said, it's very difficult for us to make statements because this is so new. As I said, the whole pandemic has blown up suddenly, and I don't think that anyone anticipated how it has affected the whole world. And so even worldwide, we don't have any precedents at the moment to know exactly what are going to be the side effects, because the vaccines also have been given for such a short period of time. So we really don't know the long-term effects of the vaccine. We don't know even overseas whether, I don't think that any claims have been commenced. I've not read about it. I've not read about it in the UK. I've not read about it in Australia. I've not read about it in the EU. And certainly in the Southeast Asian countries, I don't think anyone has actually uh, launched any claims for vaccines at the moment. But that doesn't mean it will not happen, all right? It's just a matter of time before someone decides to make a claim. And I'm just giving you the general overview of what the legislation is in Malaysia at the moment in relation to product liability, which vaccines would be a product, as well as the general law of contract and tort. All right, so I think that's what I wanted to talk about today. So does anyone want to, has anything further they want to share
Yeah.
or ask?
Thanks, Shamini, for a great talk. There's a lot to digest, and I'm sure you must be quite exhausted also. We've actually taken about an hour. We'll take a short break to give Ms. Shamini a catch of breath. And I'd just like to show a little clip from Dr. Shield. Now, Dr. Shield, as you know, has been very good at organizing all our medical legal series. So just a little in appreciation, just going to show the little clip about Dr. Shield. Well, you all guys can go and ask your questions in the Slido or in the Facebook or YouTube chat. Okay.
We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Okay, I think Ms. Shamini has gone for a little break. We will go on to Q&A. We've overshot the time. I thank you for still being with us. We will take some questions in a little while once Ms. Shamini comes back. Okay, she's back. Don't come back. So I'm going to show the questions we have on Slido. So thank you all for listening and for your questions. So Dr. Hon has asked, has any malpractice claims arise in Malaysia during this current COVID-19 vaccination exercise? And if so, what are the nature of the claims? I think you've answered that in your last bit. Nothing, yeah?
No.
In fact, wrong, yeah.
I see a question there for a second dose. Is a new written?
Yes, from Dr. Kaur. Yeah, yes.
I believe it is, because the time period from the first dose and the second dose is quite a long time. So I believe that it's important that the patient be again advised, or at least have a form and sign something. I don't think you can just say I gave the advice once and it applies for the first dose and the second dose. My view is you should.
It's 3 weeks for most of the vaccines. Is that considered long?
I think at least you must refresh their memory, at least, bring it to their attention to say that, on this date, would you agree that you are explained of the risks or something to show that that they are aware of it? Some proof that you have tried to ask them, do they have any questions?
Yeah, I doubt if it's current practice to take a fresh consent for the second
Yeah, it's
dose.
not, because I just had my second dose and I realized that they just didn't
They
say
just check.
anything, and just that's it. You go in
They
and you
assume
get the
you they
second
assume
dose.
you know the drill.
Yeah, exactly.
Mm,
So I was a bit
okay.
surprised. Okay, so
Some say anonymous is some say because you registered via MySejahtera, it is implied consent is already given, so written consent is not needed. Is that correct?
I do not agree. I do not agree because my Sejahtera is something which is formulated by the government for this public health emergency. So it doesn't mean that you've consented to take the vaccine. You see, there are two parts of consent. One is that you're not assaulting the patient. So you're right. If you registered with My Sejahtera and you turn up for vaccination, they cannot sue you for assault. But to sue you for not advising of the risk would not be covered by the My Sejahtera.
Okay. In the current mass vaccination, can doctors who obtain consent from vaccines but not involved in vaccinating be liable for adverse reaction?
Obtain consent.
Let me give you some an idea of what's going on. The patients with serious medical problems like cancer or chronic illness, if they declare this in the My Sujatra when they go for a vaccine, the government wants the doctors who have been caring for them to fill up something called a pre-vaccination authorization form.
Okay.
In a sense, it's like some form of explanation, informed consent, and saying it's okay from their side that they can go ahead with the vaccine. So you're supposed to stick, all right, and can have it either in hospital setting or if it's potentially requiring that, or in a normal vaccination center, and then we give the form to the patient, and then the patient goes to the vaccination center, has this vaccine. I presume again another consent is taken. But how much of this liability for filling in this pre-vaccination authorization, but we are not actually vaccinating the patient? So where does the liability lie?
I believe I'm sad to say that because the government has given this responsibility to the attending physician or surgeon to actually advise the patient before they go for vaccination. So you are part of that net that the patient theoretically can sue you. I don't think
This,
you can say you are not liable.
I think then, we have to be very careful what we write in the pre-vaccination form then.
I believe you have to.
I think the whole thing is becoming, and I think the onus on this consent form in a mass vaccination consent, it's practically
Yeah, it doesn't make
impossible.
sense. It
It's
doesn't
just
make sense.
impossible. It's very, very impossible. You got to keep on vaccinating. How can we achieve the herd? If you want to take a thorough consent form, maybe you're vaccinating 1 or 2 people per day only. I think that's the way it is. Okay,
No, but I
what
think
about
it also
not? Yeah.
depends. It also depends on I believe this is something which has to be negotiated between the government and the doctors that, should they be forced to do this, then, you also say that you want an indemnity or you will not be held liable, but I don't know whether that's going to work. Unlikely. And I agree with you. It's very difficult when you have mass vaccination, unless you're going to do it as like a school, to have one, video or something, and then, which
Yeah.
won't work because each patient has got different comorbidities or whatever, right? So
Yes,
it
exactly.
won't work.
What about non-doctors, pharmacists, or dentists who obtain consent? Will they be liable too?
As I said, anybody who takes the consent and your signature is on the form is potentially liable.
Okay. Yeah. So they better have medical indemnity too.
Dr. Shield.
Like, when MAs or nurses explain to the vaccinees, but the doctors stamp their names on the form, who is liable? Medical assistants, MAs, medical assistants, or
Actually, it's
nurses?
not a good practice. I actually the doctors are still going to be liable because you are the one who's putting your signature there.
Yeah.
Technically, both can be held liable, but as I say, they always take the person with the deeper pockets, so they will definitely take the doctor.
Do doctors need a separate form which states that the patient was informed of the possible side effects and risks of the vaccine? Current form does not have it.
I think what you need to do is you just need to annotate on the form. You don't have to have a separate form. You know what I mean? Of course, I know in a lot of hospitals, the standard form has a section which say explain of the risks and understand, isn't it? But I believe you can annotate. Or if it's your own consent form, you can create something else, you can create an addendum or something. If you're a clinic and you want to do it that way.
So compensation comes from where? Drug companies or MOH?
That's why, as I said, as far as I know, the drug companies have negotiated with the governments that the government has to indemnify them. So they will just wash their hands off it. So it will be the government of Malaysia. But again, as I said, what compensation are you talking about? This is for product liability, it's not for other aspects.
Okay, there's some comments on our social media. So John Doe, correct me if I'm wrong, doctors are required by law to buy medical indemnification, but there's no such requirement for nurses. So they do not have professional indemnity and they don't seem to aware they can also be named as defendant. No comments.
Yeah, can I just comment on this? You see, the thing about nurses, as I said, nurses will normally be sued not just in their own capacity, that they will be sued as an employee working for a particular organization. So that organization will normally bear the cost for the nurse. But you're right, the nurse can be named as a defendant and in theory is liable for the full amount of the claim. I think they are aware. Many of the cases I'm dealing with, nurses are now named as defendants.
Dr. Lim Kuan Ju says, in relation to infectious disease and confidentiality, public interest should override personal interest. I think it's related to the PDPA thing. And
yeah, I think there is an exception under the PDPA. I do believe there is an exception for public policy and this kind of public health emergencies. So as I said, I was just trying to draw your attention to the fact sometimes third parties don't have the right to all this, and everyone goes a bit overboard. Everyone is worried, all right? So you've got to be careful who you share the information with.
One thing about vaccination is different from patients coming to seek treatment to the doctors. These are not otherwise normal people who are aware of an ongoing pandemic, and actually most of them are aware also there are potential risks and adverse effects, and I think that sort of makes our job a bit easier. In fact, the job is the other way around: how to allay the fears which have been unfounded by a lot of false
anti-vaxxers.
Yes, and and there are a lot of funny misconceptions. You give a vaccine and then your immunity declines after vaccination, or some strange misconception. So every year we're spending more time actually allaying fears, and trying to explain the other things. You mentioned something about exposure due to SOP lapses. So recently there was this large mega vaccination center
yes.
where a lot of people fell ill.
Yeah.
Could somebody take a case, against the government, for instance? I'm just theoretically saying, I'm not saying who's right or wrong, but because of so many people fall sick because of too much crowding or allegedly not poor SOPs in such mega centers?
Definitely they can. They definitely can. And not just the government, as I personally know that I didn't know about it until recently. But in that particular center, apparently there are two parties giving the vaccination. One is a private vaccination provider, and one is the government. So certainly a patient could sue both or one of them, because they all of them were exposed.
Yeah, actually, if people become sick now and end up in hospital, government hospitals are full, they end up in private hospital. The problem about coming to private hospital
The
is
cost.
insurance companies don't want to cover. We say it's pandemic, it's an exclusion clause. Can they be actually the insurance company be in some way made more responsible or liable, rather than say, oh no, we don't cover because we cannot adjust for all these things. Can there be a class action suit taken against insurance companies for refusing to cover?
I don't think you can. Unfortunately, yeah, vis-a-vis the insurance companies, they'll clearly say it's a matter of contract between the party and them. The only way you can change it is for the government to exert some pressure on them to say in future, they have to adjust for the risk and make sure these kind of events are covered as well.
Yeah, I suspected you would say that, but it's a real problem for our patients who come in to a private side and they end up with huge bills, and insurance doesn't want to pay
No,
anything or
especially
very
in
little.
in a disease like COVID, where it requires such a lot of ICU
Yes,
admission, which is very, very, very expensive.
yeah.
You feel
So,
sorry for the patient when they've got no means to pay for it.
so when it comes to the bottom line, it also may mean the tendency to find fault at every small thing, and medical legal action actually may go up as well in order
At
to
the
help people.
moment, I think people, because they are so worried about their health status, I think at the moment it is not a major issue. But once it becomes, we know how to handle it,
Yeah,
then I think the problem arises, because then they will find fault, and
yeah.
try and make some money out of it.
That is one concern as well. And well, I mean, we hope we'll see the light at
And
the end of the proverbial tunnel. I mean, vaccination has just really got to be ramped up, I think, and we're getting there, but the road is quite rocky. Okay. Yeah. But thank you once again, Ms. Shamini, for taking us
most
through
welcome.
this. I think it's a journey of discovery, not just, not legal discovery, but discovery for everybody. A lot of things are not known. What's going
No,
to
for
happen?
me as well. For me as well. Even as a
We don't,
lawyer,
yeah,
it's it's
we
a it's a
don't
new
know.
journey. We don't
I
know.
mean, even like the AstraZeneca thrombosis thrombocytopenia syndrome, the trials did not pick it up because it's so rare. So only when you start vaccinating millions, you see some cases. Okay, and we do have now, when people are aware, they get all sorts of symptoms coming, and we have to actually exclude the vaccine. But very often, it's actually not the vaccine. Just the time relationship does not mean it's causal. So that's the difficult thing.
No, no, which is why I said it's not easy for the patients to succeed, because
Yes.
that causal relationship is going to be very difficult to establish. I mean, that's my view.
Yeah, so there was this patient. I mean, there are patients who come in with bleeding or blood clots, but actually it's totally unrelated to the vaccine. They just happen to develop something else. Yeah. Okay. So I think we've come to the end. We've overshot the time a little bit. So we'll have the QR code, Shabini. So this is the point where they get the uh,
The points.
CPD points. Yes. So here you go. Let me share that.
So,
So that's the where you open your MMA app, and where the red circle is where you tap to scan the code. All right. Please make sure you've updated your MMA app. So those of you using older versions of the MMA app may not be able to scan, or may not work at all. So if it fails, please update your MMA app. So this is the QR code. So feel free to scan. Let me check. I've just generated it, so it should take about valid for another hour or so. Okay. Okay, it worked for me, so I hope it works for all of you. Instant point. For those of you who are watching, this video will be available for watching when it, even though it's not live. So I just say once again, you can claim points using the code words which I've displayed at the bottom as banners throughout the talk, throughout Ms. Shamini's talk. And then there were in the YouTube description, and later on I'll put in the Facebook video in the comments, a link to our bulletin board where you can take the MCQs, which will ask you what those code words were. So they are spread out throughout the whole talk. So hopefully that tells us you've actually paid attention and listened to everything. Okay, so without taking too much more of your time, Shamini, thank you once again for speaking to us and enlightening us on another medical legal topic. Okay, so
Thank you, Dr. Allen. Thank you.
thank you very much. So I'd like to wish everybody good night. There are a lot of people, there are people who are saying thank you, thank you, thank you. Yeah, thank you. Thank you everybody for staying. We've overshot our time, but thank you all for listening. I think it's been interesting. It's very topical, and it's a lot of things to ponder about. I think we have to still take care when the usual good medical practice with proper SOPs, not just from the medical side but from the medical legal side, documentation and informed consent. All these are important, as you reminded us. Okay, so good night, everybody. We're going to end the talk now, and we wish you well and have a good weekend ahead.
Good night. Thank you.